guys, this is an episode whereby Scott talks law, and welcome once again to another episode of Scott talks law. So in this particular episode shall be talking about the property law 2, and we shall be talking about the contract stage. So property law 2 concerns the conveyance in property or interests in land. So we talked about the modes of land acquisition or modes of land conveyance. All those modes of land conveyance: conveyance by agreement, conveyance by inheritance, conveyance by possession, and prescription. So we also talked about the pre-contract stage, that is a stage that involves a lot of searches that are related to that particular land. A lot of search should be conducted in relation to matters in relation to that land or property in question. So this particular episode shall be talking about the contract stage that comes after the pre-contract stage in land conveyance. So the contract stage is that stage that involves the contractual agreements or negotiations and sale agreements governed by the LSK Act 2015. So the creation of transaction in interest in land is often preceded by a contract. That is, a contract for the sale of land usually proceeds the conveyance of the interest in land and the purchase. Similarly, a contract for the lease may be made first and then followed by later date by a formal grant of terms of years in the form of a lease. So a contract for the lease proceeds first, then a formal grant for the terms of years in the form of a lease. Also, an owner of land may contract or create an interest in lease, such as an easement or change. So an actual creation of the interest then follows later. So largely, contracts of the sale of interest in land are governed by the general principles of law of contract. Those general principles are just those ones that govern the contracts relating to land, the agreements. So that the general requirements of a contract, that there must be an offer, there must be an acceptance, there must be consideration, there must be intention to create a legal creation. So those are the general principles that govern this contract. They govern the normal contract, the ones that govern the contracts relating to land. So due to the value attached to land, it's also land and its peculiarity. Contracts for the sale of land is subject to more stringent conditions. So because of the value attached to land has the great value. And because of the peculiarity, there are many stringent conditions. However, the foregoing requirements do not apply to a contract made in the course of a public auction or by an auctioneer. So it also does not affect the creation of a resulting or implied constructive trust, which does not have to be in writing, but creation of equity to prevent situations where deserving parties are deprived of their rights to land. So the requirement for writing was endorsed in the case of Doris Morgan versus F. Stanbinsky, 1977 EKLR. The requirements for writing, where though a notice was signed, it was devoid of the essential terms and was also ambiguous as to who was the tenant. The agreement to take up the lease in question having been made to the landlord by the husband and the note having been signed by the wife. The court held that there was an agreement in writing duly signed by the party to be changed in accordance with Section 3.3 of the Law of Contract Act, and such there was no enforceable contract between the parties because there was no agreement in writing. So there was no enforceable. So there was an agreement in writing duly signed by the parties to be changed according to Section 3 of the Law of Contract Act, and such there was no enforceable contract between the parties. Section 3 of the Law of Contract Act has been replicated in Section 38 of the Land Act. So before parties enter into a valid contract, the parties will normally negotiate the terms of the contract. It is the common practice in the land sale transaction for parties to agree for the subject of the contract, and a letter or offer could be made either by party or other party subject to the contract. So before the parties enter into the contract, they must agree on the subject to the contract. What is the subject matter of the contract? Is it the land? They must agree on that subject matter. And the contracts relating to land, they are supposed to be written. So the rationale is that the buyer should be free from binding commitment until he has the opportunity of obtaining a legal and other advice, arranging his finance, and making necessary inspections, searches, and inquiries. So you should refrain yourself from making binding agreement, because before you're doing the searches and proper inquiries, the property and finances that you have. So the danger is that the purchaser may be gazumped, that is, the vendor may withdraw from the bargain, threaten to do so if the expectation of receiving a higher price. So this person who is selling this property, if they has entered into an agreement, this person then can change his mind, then sell the property to another person at a higher price. So not to allow this instance or these cases, the person should not, before entering into this contract, should look whether you should refrain yourself from entering into a binding commitment before you search that piece of property, or before you make subject matter, do those research with the vendor. So the vendor gazumped by the purchaser. So the effect of the phrase subject to the contract is that there's no contract, either party is free to repudiate the bargain until a formal contract has been drawn. So there's no contract before a formal contract has been drawn, and either party can repudiate from the bargain. So in order to prevent gazumping or gazundering, the parties may enter into a lockout agreement, which effect prohibits the expectation of receiving a higher price. So there's this lockout agreement that prevents those parties from going to and entering into contract with another party, different party apart from the two parties, that will make him receive a higher price. So there is such that lockout agreement that will prevent gazundering by the purchaser. So however, the lockout agreement may have limitations in that either may not negotiate with the third party, but at the same time refuse to take further negotiation from the other party until the lockout period is exhausted. So it can have limitations because though the second party cannot negotiate with the third party, but it will not take further negotiation from the other party, not take further negotiation from the party, the buyer. The contract for the sale of land usually contain the sale of agreement, usually contained in an agreement for sale. This contract is contained in an agreement for sale, as long as the agreement complies with the minimum requirements like writing, signing, execution, or attestation. The parties are free to negotiate the terms of the contract and put them in writing form. So the parties are free to negotiate the terms of the contract and put the terms in writing form. So there are clauses that contain this contract for the sale. Those clauses, and you should know that the standard format of a contract for the sale of land has been developed over time. Traditionally, the format is what is normally called the LSK conditions of sale. So the standard format for the contract of the sale of land are referred to as the LSK condition of sale. And the standard format of a contract of sale of land has been developed over time. The format on how this contract should look has been developed over time, and traditionally the formal is what is known as the LSK condition of sale. So the latest one is that one of 2015, LSK condition of sale, and it provides for a template that guides the conveyance in terms of conditions to be contained in the sale agreements. Though the conveyance is not bound to finality, follow the terms and conditions therein is merely a guide. So it's not bound to finality, it's just a guide to how the contract of sale of land should look. So the condition of sale 2015 is accompanied with an agreement for sale layout. Let's look at this silent features of a sale agreement, and a simplified format of sale agreement will contain the following clauses of information. So the features of a sale agreement has these 16 clauses, and we're going to look at all these clauses to understand the silent features of the sale agreement and the conveyance. So the first clause is the commencement clause, and this one contains the outlook, the title, the date, and the parties. So this contains the nature of the document, the date and parties in the transaction. The nature of the document is the agreement for sale. The date will be the date the agreement is entered, that particular date where the agreement is entered. Parties will be the vendor and the purchaser and their addresses. The usual practice is to provide a cover page which also contains this information. So the cover page must be provided. The actual date in which the contract is entered must be provided in the commencement clause. The parties must be stated, the vendor and the purchaser, the buyer and the seller. The nature of the document. So the second clause is the recital clause that comes second after the commencement clause, and this is like this the preamble of the entire, or the summary, the executive summary of the entire sale agreement. So the recital clause is the descriptive part, which usually begins with whereas. That descriptive part, it states the nature of the proprietor interest in land. So whether freehold, leasehold, whether freehold, absolute, or estate is a free, simple, or lease. So the nature of the proprietor of the interest is like, what is the nature of land? This is contained in the recital clause, free, simple, and the history of the property. What is the history of the property? The events which may have taken place to the property prior to the sale, e.g. subdivision, etc. So the events that may have taken. Was this land subdivided? Was this subdivided before? The history. What is the history of this land? Was this land shared before? What was the actual size of this land? So the history of this land and the nature of the property, the description of the property. So the property, if the property is sold together with the fitting, it needs to be stated. And the fitting includes the hanging panes, the carpet, the refrigerators, the curtains, the bed, TVs, etc. that are not permanently affixed or attached to the property. So the fittings are those things that are not permanently attached to the property. And if this property, this described property has those fittings, those fittings should be described in the recital clause. So unless otherwise stated, property not sold together with fittings, property is not sold together. So unless otherwise stated, property is not sold together with fittings. However, fixtures are deemed to be sold together with property. So fixtures are those that are permanently attached. So it should be stated whether these fittings are to be sold with the property or not, unless otherwise stated. But there are fixtures that should be sold with the property in question. Fixture item permanently attached. Fittings are those that are temporarily attached. Fixtures are those that are permanently attached to the property. Fittings are those like curtains, TVs, those that are not temporarily attached, and fixtures are those that are permanently attached. Fitting can be sold with the property or not be sold with the property, and fixtures are those that can be permanently attached to the property, e.g. building wardrobes, bathroom suites, sinks, bath, toilet plugs, wall painting, light, fitness, etc. So when you go to buy a house, there are those things that are in those houses that are not permanently attached. We have chairs, we have TVs, we have carpets, we have curtains. So it depends with the person who is selling. This person can agree to give those things or sell them with the property, and he can also agree not to sell them the property. And there are those things that are fittings that are permanently attached to the property. We have bathrooms, we have toilets, we have those that are permanently attached to the property. Those ones are supposed to be sold with that property in question. Things like bathroom suites, sink, bath, toilets, plug, wall paintings, light, fitness, etc. So it's stated that what the parties have agreed to do in the sale of the land. So it depends on what they agree. So this recital clause is just an executive summary or the sketch or the preamble of the entire sale agreement. So the third clause is the interpretation of the definition clause. The third clause, the interpretation of the definition clause, and this contains the definition of certain terms in the agreement. So you have those terms that should be described well or interpreted. So there are those terms that are not in English, and those terms that are not in English should be described well and stated well. So this can be identified by capitalizing the first letter even if it appears within the middle of the sentence. So if you see that there's a capital letter in between the sentence, then you should know that that one is an interpretation clause, that has been interpreted. So the fourth clause is the consideration clause, and this sets out the amount of the price, amount of the purchase price, and the modes of payment. Usually a deposit of 10 of the purchase on the execution of agreement. So unless otherwise agreed, the deposit is paid to the vendor's advocate to hold as a stakeholder pending the completion. So in the consideration clause is where the deposit of 10% is paid, and this money is held by the vendor's advocate. So the advocate is the one who are involved in holding this money. So vendor's advocate holds the state as the stakeholder pending the completion. The stakeholder of the both. So the stakeholder of the stakeholder for both parties, and the lease money depend on the outcome of the transaction. So if the sale goes through, the lease money to the vendor, but if the sale fails, the lease money to the purchaser. So it depends when the transaction will fail or not fail. If it fails, then the money, that deposit, should be given back to the purchaser. But if it passes, then the vendor should have that deposit. So however, in situations where the deposit is paid to the vendor's advocate before a binding agreement is entered, the advocate holds the money as a trustee for the purchaser pending entering into a binding agreement. So the vendor's advocate holds that money as a trust before the final agreement is entered. So the consent of parties is required before dealing in the same. The parties must give consent before a deposit is paid. Unless otherwise agreed, the balance of the purchase is paid within 14 days of the registration of transfer in the name of the purchaser, but not later than the completion date. So the money should be paid after the 14 days of the registration of the transfer. So but not later than the completion stage, unless otherwise agreed. So the balance, after you pay the deposit, that balance should be paid before the end of 14 days after the registration of the transfer in the name of the purchaser, not later than the completion stage. So let's look at the fifth, the completion clause. So the fourth one was the consideration clause. So the completion clause is the fifth clause, and this says the clause stipulates the period within which the party should have performed the obligation unless otherwise agreed. So the completion period is usually 90 days from the date of the agreement, or on or before the completion. Certain documents known as the completion documents ought to be delivered by the vendor's advocate to the purchaser's advocate. The completion documents are usually released by the vendor's advocate in the exchange of the undertaking purchase or the financer's advocate, depending on the cash or finance purchaser. So if the documents undertaking is acceptable, so this completion stage involves the documents to be transferred. If that so it stipulates the period in which the party should have performed the obligation, and it also involves the transfer of completion documents. So the completion documents usually include the documents that are necessary to effect a transfer of property into the name of the purchaser being entitled. So includes those documents or clearance or consent or discharge in template. So duly executed and transferred triplicate. So copies of ID and KRA pins and 3 colored passports, photograph, special consent. The purchaser's advocate may also call for a nil statement and a receipt for payment of the electricity and water if applicable. So the sixth clause in the matters arising affecting the property. This is where they stated whether property is subject to any easement, covenant, rights, restriction. It is contained in the title, which may limit or restrict or set out rights that the owner has in the title. So there are those matters that affect the property in question: the easement, the covenants, and the rights. So usually property sold is free from any encumbrances like charges, so that there is a charge registered against the property. The same ought to be discharged first. So the seventh clause is the possession clause. This is the clause which stipulates the nature of possession to be granted on and at what point. Usually the purchaser is granted a vacant possession unless otherwise stated, where, for example, the purchaser is to take over existing tenant's possession is normally granted on or before the completion. So before the title completion date unless otherwise agreed. And the eighth clause is the penalty or remedy for breach, and the set out penalty against the party if breach of remedy available to the innocent party. To availing himself to the remedy, the innocent party ought to serve 21 days completion notice, to be served 21-day completion notice on the party in breach. If the purchaser is in breach, the vendor may extend the time for completion by the purchase or resigned by writing notice the agreement upon which the purchaser shall forfeit the 10% deposit liquidated damages. So the notice must be given before the penalties. So if the vendor is in a breach, the purchase may extend time for completion or rescind the agreement by written notice. Agreement upon the purchase shall forfeit 10% deposit as liquidated damages if the vendor is in a breach. So the purchaser may extend time for completion or rescind the agreement by written notice upon which the demands for immediate full refund payment. We shall later see other remedies available in conveyance. So the ninth clause is the incorporation of law society conditions of sale. The incorporation of the law society condition of sale. Here the parties may incorporate the LSK condition of sale as long as the sale agreement are not varied or inconsistent with the condition of agreement. So parties may specifically pick out certain terms in the LSK condition and vary them. So the 10th is the cost. The 10th clause is the cost. So the 10th clause is the cost, and the 10th clause is the costs. So the 10th clause is the clause on the cost, and here parties state who is responsible for payment of legal fees and other costs. Is it the purchaser or the buyer, or other costs and other fees? So like the stamp duty, who is supposed to pay the stamp duty? The parties must decide amongst themselves the transaction costs. So at most cases, the purchaser who pays or is responsible for the stamp duty, but it must be agreed by the parties. The transfer of costs, usually the person must has his own advocate's costs, and will ensure that receive the purchase pays stamp duty and transfer duty. So the 11th clause is the miscellaneous clauses, and these clauses contain sub-clauses like non-waivers, cumulative remedies, severability, and ensuring nature of contracts or non-waivers. Where a party delays or forced to enter into a right to seek remedy is not precluded from danger from doing so later. So on cumulative remedies, it means that no other remedies available in law are excluded. On severability, where some clauses are not enforceable for illegality or other reasons, the remaining clauses are not affected and remain valid. On the enduring nature of a contract, despite the completion, the agreement shall continue to be enforced for as long as the necessary for mutual. So the 12th clause is the notice clause, and this is one which stipulates the manner, form, and period of the notice to either in respect to the transaction. It may provide that a written notice be served by the registered post on the last known address of the parties. So the notice being a period of 14 days. So the 13th one is the jurisdiction clause. This one stipulates the law governing the transaction, either the Kenyan law, and the place of adjudication of dispute, says the Kenyan court. So it stipulates the laws and the place where this case should be adjudicated. So the 14th clause is the testimonium clause, which starts with the witness thereof, and which links the proceeding parts of the agreement with the execution or signature clause. So the testimonium clause links the proceedings with the signature clause, the proceeding part of it, of the agreement with the signature clause. The 5th clause is the execution clause, where the parties sign or seal the agreement as per section 44 of the Land Registration Act, and all parties concerning an instrument affecting the disposition of land, including the safe figurement, and shall executed by the way of signature and a thumbprint or other marks. So you shall sign, you can place a thumb print or any other way of showing signature. So in the execution is by corporate body. The execution is by corporate body or association, the corporate society, or any other organization. Execution is done in preference of an advocate, magistrate, or a judge, or naturally the public, who, as you shall see, must see and complete a certificate of assertion. The 16th clause is the verification clause, the verification clause or the attestation clause. So this is where the witness sign in witness to execution and give a certificate of attestation or verification. So Section 45 of the Land Registration Act provides that person executing an instrument shall appear before the land registration public officer or any other person, including the judge, magistrate, registry, property registered under the High Court Registration General, and deputy assistant or administrative officer, superintendent, principal advocate, or bank. So rules of registration not in the Substantive Act. So guys, those are the clauses that are set out in the Land Registration Act that govern, that are set out in the case LSK conditions of 2015, the latest one, that are concerned with the land sale agreements and this contract of a land sale agreement. So there are 16 clauses, and they are set out in that in the contractual stage. So I think that is the end of my episode on the contractual stage, and have a nice day.